Welcome everybody to today's session. The Latino Chamber of Commerce is welcoming everybody. Thank you for joining us today on this leasing and renting commercial real estate webinar. We have a very special guest, and he's been working with us for a little over a year. Luis has been providing the content of all these sessions related to commercial real estate. So our business members and anybody that owns a business have a little more information, and any business owners can be prepared ahead of time. And in the case of making a purchasing decision or leasing decisions of their business, or of their the building of their business or the property that they want to install or start a business. I want to just tell you a couple of things about our presenters today. Just quickly, Luis has over 10 years of experience in international business, contracts, negotiations, development of subsidiaries, exports, imports. He's a Minnesota residential and commercial real estate agent, active for over 15 years, and he's been a past director of membership at the National Hispanic Real Estate Professionals Twin Cities chapter. He has all the certifications, and I know, Luis, that you got recently you got one new certification. Maybe you can talk a little bit about that, but I want to welcome you too, and thank you for participating with us. Thank you for presenting today. So with that, Luis, I will let you start your presentation.
Thank you very much, Fabio. As always, it's a pleasure and an honor for me to be able to share a little bit of knowledge in commercial real estate for the community and for everybody. As you mentioned, I had a new denomination, is the CREN. It's a Certified Real Estate Negotiator. So we can negotiate a little bit about contracts and leases and purchase agreements, letters of intent, and so forth. Today, the topic is super vast, super big. So what I'm going to try today is to go in a very high level, and I'm going to mention several aspects of leasing and how to approach the leasing of a property, whether it's a warehouse, whether it's a multifamily building, whether it's office, etc. It's a small office, or you can rent the entire building. We can do that in commercial real estate. So let's dive in and prepare yourselves, because this is going to be very interesting topic. As always, let me have a little bit of housekeeping. And let's take out the elephant in the room. First of all, I am a CPA, but I don't do accounting and I don't do taxes. In my practice, I did budgeting and treasury. So I am not going to give you any advice for accounting or tax purposes. And also, I am not a commercial or a real estate lawyer. So I will not give you any advice. I cannot give you advice because obviously I'm not a lawyer. Okay, so having said that, I will just give you my points of view, my suggestions, and that is the extent of the presentation. Other than that, let's dive in. And as always, I go from the very general to the very particular. And of course, throughout the presentation, I will give many examples. So you have a little bit of a frame of reference or comparisons. We're going to start with the definition, the kinds of commercial leasing in real estate. Everything is commercial, of course. Negotiations, a very important topic. The lease agreement, which normally is between 50 to 70 pages. And then throughout the presentation, I'm going to be addressing a little bit of negotiating this clause or negotiating this opportunity in the lease or in the process, okay? So if we start with the definition of lease, commercial leases, it is basically a business contract. And I always like to say different words than what is written here. I don't kind of like to read what is there, because what is there is written, and you can always go back and take notes and write what is there. But what I talk is a little bit different in terms of wording, but it's the same objective, okay? So coming back, definition is a business contract between two parties. It can be, of course, the landlord of the owner and the tenant of the lessee. We're going to see the lessor and the lessee down this page, or transparency. The owner is the landlord, the lessor. The lessee is the tenant of the person that is renting. It can be a company, it can be an LLC, C corporation, S corporation, which normally it is better for you, lessee, to have that instead of your personal name. We are going to see why. The rent, obviously, is a periodic payment that the lessee makes to the lessor for the very important, these three elements: use, possession, and enjoyment, not the property. Okay, you don't have the property, and this is also temporary. This, in legal terms, is called usufruct in English, or usufructo in Spanish. It's very, very important to define these three elements in the lease, which is the temporary possession, but not the property. You can enjoy and you can use the property, okay? More terms, and we can talk all morning in terms, but I would like to stress the more important ones for my personal point of view. Security deposit is the money that the lessee gives to the lessor or to the owner for at the start of the contract, and it should be given back at the termination of such if the property is in a satisfactory condition. Here is a very important trick that we can do as owners or landlords. If you are going to require security deposit, my recommendation, my suggestion, is that you ask for the lessee to give you not cash. Why not cash? Well, imagine that the lessee or tenant goes bankrupt. Then you, as an owner, cannot touch that money, because that money is going to be in a trust account, and then that is going to go to the court, and you kiss goodbye your deposit. So what I suggest is that you ask for the tenant to give you a letter of credit. The letter of credit is guaranteed by the bank, and when the tenant is at fault, you immediately collect that deposit. Interesting, huh? Assignment versus sublease. Imagine that you have a tenant, and this is a part of termination also. You have a tenant, or you are the tenant, that you cannot finish the lease. You have a lease for 5 years. Today is year 4, and I'm sorry, but the business is belly up. I cannot sell anymore. I don't have any money. I owe everything, everybody. So you have to write these clauses in the contract. Assignment or sublease. If you're going to assign the lease, you basically, as a tenant, get out of any responsibility from the lease anymore. So if Peter assigned the lease to Mary, Peter is free of any obligation, and Mary is going to be subject to all the clauses of the lease in that moment. Versus a sublease. If you, tenant, are going to sublease, that you can do if you write it in the contract, then you stay liable. So in the same example, if Peter gives to Mary a sublease and Mary doesn't pay, Peter is the one that still is responsible for the contract. Another trick that we can do here is that the original tenant can negotiate whether it's assignment or sublease for different articles and different terms of the lease. It's up to the new tenant to accept that, and obviously the landlord to concur, to agree with those different terms, as long as obviously it's not detrimental to the landlord. Okay? Very, very interesting, the assignment or the sublease, as well as the security deposit. Condemnation, as we have seen in many properties, especially after COVID and after George Floyd, is when a property size or the government gets it because they didn't pay property taxes, or definitely the inspector went and it's a crack house or drug house or other illegal use of such. A stopper certificate is a very good and very important certificate. Very few people know what it's all about. And it is basically a document that the lessee makes as a tenant to the new buyer. And the buyer believes what is written in that document. Okay, so that's a stopper certificate. Before renting commercial real estate, it's very important to do your homework prior to even make letter of intent. What is that homework? As a tenant, we have to assess the location, meaning we have to go around the neighborhood, make sure that there is enough parking. I have a situation of a restaurant. We wanted to rent a space, and guess what? The city did not allow a use of restaurant for more than 3 tables, because 3 tables times 4 people, normally every table has 4 people, is 12, and there were only 3 parking lots assigned to the restaurant, or to the place, excuse me. So therefore, 12 versus 3 doesn't match, no permit, no restaurant. So you have to be very careful with all these little details that can make a big difference. You have to do, obviously, always physical inspection and professional third-party inspection. Some properties have homes association, homes owner association, but in this case, it's obviously commercial association. Careful, because the articles can be very tough, especially in commercial. You have to see all the environmental issues. For instance, if you are going to sell liquor, you have certain rules because of the schools around. I believe it's 300 or 400 yards, or depend upon the city. Obviously, if it's a dispensary, forget about having a dispensary or selling marijuana donuts if it is in front of a school. You have to be very careful in your estimates for repair and conditioning of this place. What is your budget? All capital letters. We are going to talk very, very in detail about you have to have money in order to rent. And it's kind of a counterintuitive, but yes, you have to have money because of the conditioning and because of capital, working capital, and capital improvements. Obviously, you have to evaluate the lease agreement. We start to negotiate the TI, which is tenant improvements. We're going to dive into this topic later. The cash allowance, grace period, and option terms. We're going to dive in those ones. And very, very, very important, the hidden cost that sometimes, and happened to me, we were signing the lease already after 4 months of negotiations, and my client signed the lease as a tenant with a sublease, of course, and guess what? The electricity was not considered, and we were talking about 12,000 square feet, and that was about $1,000 a month, times 12,000, and almost the deal was broken. because of this little detail of the electricity. So be very careful what are the costs. We're going to dive more in detail about that. And again, the permits that we talk about, if you are going to put a liquor store or if you are going to have a car shop, painting is very delicate because a lot of cities don't like to give permits anymore for working in cars, change of oil, change of tires, those kind of things. And of course, your insurance options, very important. If it's going to be 1 million or $500,000 per incident per year or for the life of the policy. Have to be very careful about that because the suits here in the United States are right and left. Careful with your coverage. Letter of intent, once that we did all that homework, we have a very clear and good idea what are we renting and how we are going to approach the rent. So we write normally a letter of intent, which the most important articles are the monthly lease, the rent deposit, and here is a very interesting situation. If it is going to be a new business, even though your father and your mother and your uncle have 10 restaurants, but you are going to put as a daughter or a son your own restaurant, the landlord doesn't care about that. They are going to treat it as a new business. They are going to ask you for a business plan, and probably they are going to ask you for 3 or 4, maybe 5-month deposit. Again, cash versus letter of credit. Conditions of the leasing. Well, here again, because you are going to do all the possible inspections, you are going to negotiate the outcome of those inspections. What about if the roof is leaking? Who is going to pay that? The utilities, are we going to rewire? Are we going to make new piping because of a hair salon? The hair salon consumes a lot of water and needs specific detailed piping versus if it is a lawyer's buffet or lawyer's office. County and city and probably even state permits. I do not know if you're aware that the liquor stores have a very specific permits, obviously, but every city has their own rules. At the beginning of the year, it says the city of St. Paul or the city of San Luis Park says, we're going to issue 10 permits this year for liquor stores. And they can be gone in January, or you can be in November, and oh yeah, this is the last one, we're going to give it to you. So be very careful with your permits. Site condition, that's no-brainer. Repairs and everything else that it can be important. For instance, the bathrooms have to be ADA. That is the rule, that is customary to have the ADA, the act disability situation. Commencement date versus occupancy date. This is very important because when we finish negotiations of the lease, we're going to say, okay, we're going to commence the 1st of July. However, I'm going to occupy in September 1st. Why July, August is not occupied? Well, because we are going to do all the conditioning, all the piping, the new painting, the new floors. Probably the bathroom needs a little brushing, painting, the kitchen. If it's going to be a restaurant and it doesn't have a hood, believe me, it's going to be 3 to 4 months easy, okay? So then you start to negotiate the TI or tenant improvement and the concessions, and of course the grace period or free rent. We're going to talk more, believe me, a very, very short period of time. When you write a letter of intent with your commercial real estate agent, it's super important to write the non-shop clause. What is the non-shop clause? Well, it is a clause that says that as long as we are negotiating the letter of intent, landlord or property manager, you are not able to negotiate or to make any marketing of the property in question. That is very important for you to cover your butt, your neck, your back, because I have had, believe me, 3-4 months negotiating the letter of intent. And if you don't put the non-shop clause, one day the landlord says, thank you, I have another company, I'm going to go with them. And all your homework, all your inspections, all your time and effort and expenses are going to the drain. So be very careful with the non-shop clause, okay? Let's see, and let's try to approach this topic in different ways. And these are the terms of the real estate, a commercial real estate lease. We can go from the point of view of responsibilities, or we can go from the point of view of the terms. Responsibilities and terms are basically hand to hand. We start from the most flexible or less amount of obligation from the tenant, and that is called the net or single net or 1N or N, is where the tenant pays only, obviously, the base rent and the property taxes. Okay, the base rent is the base rent. And the property taxes, period. The landlord pays for everything else: electricity, water, garbage, capital expenses, etc. Then we go to the next level, which is double N. That is when the tenant pays for property taxes and the insurance, or the proportion. If you are in a strip mall, obviously the proportional part of your lot or business. If the strip mall has 10 tenants and each of the tenants has 10 square yards or feet, and you have one of them, well, it's going to be the 10th of the total. It's proportional for the taxes and the insurance. Careful to negotiate the water, because if your neighbor is a hair salon and you are a lawyer, I think that you are going to use less water, so you have to negotiate that is not going to be proportional in your lease. So be careful with those little things. Then we jump to the triple net, and that means obviously all the property taxes, the building insurance, not what is inside, careful. What is inside your lot or your property, well, not your place, your space, you have to insure, okay? All the computers, etc., etc. The outside, or what we call the envelope, is what the landlord will insure. And also, it is included the CAM or common area maintenance. Here is where the tricks are very, very visible. You be very careful with all the CAMs. For instance, if the roof needs to be replaced or fixed, who is going to pay that? And the leak is in your space. That's a capital improvement, and that has to be written in the contract, and that has to be for the landlord. If there is a need for replacement of the windows, who is going to pay for that? Who is going to pay for the sidewalks, a repair of the garage or the parking lot, the lightening? All those little things are very important, because those can be very, very expensive. And if you don't write it in the contract because of ambiguity, guess what? You go to court, and normally the judge is going to favor the landlord. So careful with that, okay? Let's utilize a little bit our mind, and let's make an example of a triple net. You are going to rent a restaurant and space, obviously, and the landlord says, okay, I'm going to give you $15 the rent for triple net, that is per square foot, and $5 per square foot in CAM. What is included? And we talk a little bit about what is included. So, okay, we say $15 plus 5 is 20. If our space has 1,000, is 2,000. Or let's say, let's go a little more user-friendly. It's 14,000 square feet times 20 is 24. 24 divided by 12 months is 2,000 a month. That is how you calculate the rent per month. All these leases, in all these leases, tenants, careful, are responsible for the proportional share of the fees. You can negotiate, for instance, the garbage. Again, if it's a restaurant, I think the restaurant is going to throw a lot of garbage, and you are a travel agent or travel agency. So, hey, you know what? I'm going to pay less for garbage and less for water and less for electricity. The restaurant is open 14 hours a day. I am open only 8, etc., etc., etc. I put here ambiguity. You have to be precise. Precise, precise, precise. There is another kind of lease also. We mentioned 3 already. This is the 4th, and this is called the percentage lease. In this kind of lease, the tenant is going to pay a predetermined amount of base rent, and each month is going to be a percentage of his monthly rent. That's a very interesting approach. Huh? This is sometimes commonly in retail. Why? Because of the seasonality. This is a classic example of triple N. If you are the owner and you rent it to Walgreens, you can go to Australia because every first of the month you are going to receive a big check in your checking account, and you don't worry about capital improvements, parking lot, windows, insurance inside, insurance outside, water, etc., etc., etc. Walgreens will pay for all. More lease terms. This is full gross, full service gross, and this is where the tenant is going to pay one check, and the landlord will cover all expenses. The tenant pays to the landlord one fixed fee, and from that fee, the landlord pays water, property taxes, insurance, all the maintenance, etc., 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 and the janitorial. In the case of an office, for instance, you have to be careful who is going to be the one responsible for cleaning the inside office every day and throw the garbage every day. Utilities, common area maintenance, taxes, etc., etc., etc. There is another one. Okay, this is very, very common in strip malls. You go as a tenant, and the landlord says, okay, give me $2,500 a month, and I take care of everything else. But you have to be careful with insurance, okay? Again, I told you about the whether it's per incidence, per year, or for the life of the policy. Another one is the modified gross. This is a hybrid, and this is a combination between the triple net and the full service gross. This is very useful also for strip malls in which you negotiate every item of the CAM, okay? And this is where we big time differentiate our leases from residential. Residential is very well regulated, very tight. There is really not that much room for improvement or negotiation. But as you could see in the last 10 minutes, commercial, you can negotiate even the water, okay? So everything is negotiable in commercial. This is a classic strip mall in which there are, 7, 8 different businesses. You occupy one business or one space, and it's different. The men's warehouse than the restaurant, no? Why? Because of the water, electricity, etc. Now we're going to dive big time to the TI, free rent, and cash allowance. Tenant improvements. Careful with the definition because this is the amount of money that the landlord can offer you, whether it's per square foot or a set amount. I have an opportunity to negotiate the TI with a landlord. They gave us $50,000. Why? Because obviously the contract was going to be for 7 years. The capital improvements were going to be in the neighborhood of 150,000, and the tenant has very good reputation in the business world. So for that reason, we were awarded $50,000. But guess what? This is not free money. This was not given away because it was TI. We have to repay in 7 years the proportional part per month back to the landlord. The interesting thing about this negotiation is that we did not pay, or we are not going to pay, interest. And if you know, interest is now 7, 8, 9, credit cards 30%. So if you have 0% in 7 years, 50,000, that would be a good situation for the tenant. Free rent, as we commented, the landlord can give you free rent for the few months that you are going to condition the space. Again, whether it's a hair salon, restaurant, or whatever other kind of business, you have to have conditioning. And you ask 3, 4 months, permits, very important, and that is written in the letter of intent. If I don't get the permit, I don't rent, period. There's no if or but. And what you pay is the CAMs. Why? Because the CAMs are basically, in general terms, the property taxes that you have to pay no matter what, and insurance that no matter what you have to be insured. So you even can negotiate those two with the landlord and say, okay, I'm sorry, but I'm not going to use water and I'm not going to use any garbage, etc. So I'm just going to pay you the insurance and the property taxes while I am conditioning the space. And it's going to take me 4 months. So that's the only thing I'm going to pay you. In 4 months, yes, I will occupy, and then I will start paying the rent fully. Cash allowance, again, it's the money that the landlord will give you for tenant improvements. And in many cases, again, you negotiate, say, okay, you give me cash allowance of 10,000, but I'm not going to repay you. Why? Because my lease is for 8 years, 7 years. And they might say, yeah, hey, that's a very interesting lease. We will go for that. So very, very important to differentiate the cash allowance versus the tenant improvements, okay? This is one example of leasing in empty space. As you can see, you have to do everything here to condition your business, except the bathroom, because the bathroom is already ADA. And in the back, it's just a empty shoe box, which probably you are going to have racks, etc., for your merchandise, inventory, etc. But as you can see, it doesn't have the front desk. It doesn't have tables in the case of the restaurant, or cameras for security. Very important is the sprinklers. Who is going to pay in the event that the sprinklers get broken or doesn't work? Because you have to test them before occupying, obviously not after, because you have all the furniture. But I would recommend you to test the sprinklers. If you don't have written in the lease or the contract, guess who is going to pay? The tenant, okay? So even that, you have to be careful who is going to pay. If there is a riot, okay? Who is going to pay for the windows versus a tornado, okay? What about, you see these cables here, the blue cables there? Imagine that they make a short circuit and all the electricals go burn. Who's going to pay for that repair? Are you going to pay for that repair? Or the landlord is going to pay for that repair? You have to be very, very specific why and how and who and when those little things are going to be cured or solved, okay? This is another example, but the difference is that everything is there. You have even the sauce. You see here is a ketchup or buffalo or Cholula sauce. It is included in the rent. So obviously, you are going to negotiate 2 times, one with the landlord and the other one with the ex, quote unquote, business owner, the restaurant owner that he might be going to retirement, he might die, and then the children don't want to have the restaurant. I mean, it can be a lot of situations why the restaurant is there, the equipment is there, nobody cares, and you're going to arrive and say, okay, I'm going to or either buy this or rent with option to buy. Again, the imagination is the limit. You can negotiate. If there is a walk-in, I don't want the walk-in, take it away, etc., etc., etc. Everything is negotiable, remember. The floor, I don't like these tiles. So if you want to take them away, fine, but I'm not going to pay you for those tiles, etc. Let's negotiate. And the rent, obviously, to that owner of the equipment is going to be negotiating with you. Let's dive into a more complex situation here. And let's talk about when you are going to think big and go for the big kahuna. Let's imagine that you want to lease all this building and then you are going to buy it in 5 years. You can do that. You can you can rent a complete entire strip mall. Remember this strip mall? You can rent it all with option to buy in 3 years, in 5 years, in 10 years, in 7 years. You can do that in commercial. Remember, leases are not that regulated as residential. So let's dive how we do that. And it's a very, very interesting chess game here. So if you please pay a lot of attention because it's very, very interesting approach. What you do first is obviously, I'm just going to give you one example because every asset class will have a different approach. But basically, in general terms, you are going to do your physical due diligence, whether it's number one with your commercial broker and then with your commercial inspector. Very super important, the environmentals. The appraisal, you are going to have an appraisal so as to base your rent and the purchase price in the future. In the case of in the case of the multifamily, I will ask for 3 years rent roll and I will make a lease audit. What is a lease audit? Well, I will read the leases that are in place today, whether it is month to month or 5 years and it's going to expire in October. What is my risk for that? Okay. The rent roll will give you, and this has to be actual numbers, not forecasting. This is going to give you a clear picture of your gross income. And obviously a financial audit is going to give you your actual expenses. Therefore, if you have gross income minus expenses, what do you have? Net operating income. A net operating income divided by a sales price will give you a cap rate. Remember? So then you go and you compare that with the market report. What is the price in the market for this property? And you start to negotiate that in the future for the future price. Or for the rents that are today, which might be below market price or they are above market price. So very, very important approach to do your homework even before approaching with a contract or with letter of intent of a master lease is called. I want to rent all the building. I want to rent all the street mall, etc. All the office building. There is 10 offices in the building. Well, I want to rent it all, okay? Or a clinic building. And then obviously title report. Why? Because we don't want to have a cloudy title in which, as you know, a cloudy title is because there is a suit. The classic one is a mechanical liens in which the landlord owes some monies to somebody, the plumber, the electrician, the carpenter, the tile company, and they have not paid, so they have a suit, and you do not know that. You rent with the master lease, and guess who is going to be crucified? You. So be careful with the title report. It has to be clean title. That costs $300-400 is the best money invested. Then we start to dive into the master lease. This is going to be combined with the general lease, and obviously is going to be some clauses that are specific to the master lease and some clauses that are in the general lease, but also are included in the master lease, okay? Definition of the premises, the term, very important, the term. Whether it's going to be 3 years, 5 years, 1 year, 7 years, and then with the option to buy or not. Security deposit, we talk about it. The initial and subsequent monthly payments, as we know, now we are playing both sides, you see. One is the side because you're going to become kind of the landlord, yeah? You're going to collect the rent from the tenants that are today there. And also you are going to turn around and you're going to be the tenant paying to the landlord, okay? So you have to be very aware of what kind of contracts there are in place. And by signing the master lease, you will be able to raise the rents to your tenants. And guess who is going to pocket that money? You. Care, repairs, and alterations. Come on. If you see that the roof is leaking, you pretty much are going to or either diminish the price or ask the landlord to repair it. What kind of insurance there is? I will go to the marshal and I will ask if there has been a fire in the last 5 years and how the fire was solved, because sometimes it was not solved according to the law, meaning they did not pull permits. Is going to have an inspection and you are going to be crucified. Careful with insurance and claims. Any kind of claim of insurance. Assignment and subletting, we already talked about it. Access from landlord, yes. Even though you are going to quote unquote become the temporary landlord, the original landlord has the right of access of the property. Have to write it down, how, when, where, etc., to what extent is going to have access to the premises, and it has to obviously tell you in advance. Interruption of service. This is a very interesting topic because remember, Floyd, COVID, tornado, fire, etc. You have to write all of these possibilities in the lease contract. That is why the lease contract is 50 to 70 pages long, because all of these situations has to be written and not in the general terms, but in very specific terms. For instance, let's say that you have a fire versus bankruptcy, and you are going to have interrupting service, or you have a tornado, or you have COVID. In the era of COVID, thousands of tenants went to court and claimed that it was a force majeure. or major force or act of God. And guess what? Out of the thousands of tenants that went to court, because it was not specified that it was a pandemic, and pandemic was produced by biological means, all of the 1,000 people that went to court were denied. So you have to be careful with interruption of service. You have to put everything in your imagination that will produce an interruption of service and how you are going to get out of there or cure. You can have 6 months of 50% rent and then cure. That's one part of negotiation, no? Surrender is when you give back the premises to the landlord. Continuing, we have 17 clauses here, which I think these are just the main ones. I was reading a master lease that I had the opportunity to be part of, and there were 49 clauses and 73 pages long, the lease. I am just going to talk about 17, which I believe is the most important. Permits and zoning. Okay, imagine that again, you have the multifamily, but down the street level, there is 2 businesses. One is an insurance guy and the other is a hair salon. The hair salon is going to go out, and then you want to put a liquor store. Guess what? Maybe there is no permit for that. So you have to be aware what kinds of permits are allowed and what kind of businesses you are going to most likely put there. Again, with a master lease situation. Default, very interesting one. Why you are in default? Because the business went belly up, because of pandemic, because of tornado, rain, flood, fire, or just because you decided to go to Europe and you don't pay. So you have to write everything but the trip to Europe in the lease. And of course, the right to cure. Very, very, very important. Sometimes, hey, the business is seasonal. So in January, February, a restaurant is not the same as November, December. So you might be at fault. Well, in the lease, you write that in the event that tenant is not able to pay the rent in the months of February, March, it has 120 days to cure. You see, and that is all. Renewal, again, if you're in a good standing with the lease, obviously the landlord will love to renew the contract. But then, because you're very smart, when you wrote the original lease, you put whether it's with option to buy, no option to buy, and also very important in leases is that for every year, there is going to be an increase in rent, which you can negotiate, of course. Landlord, I have had contracts that they want 5, 6, even 7% per year increase. I have negotiated 2 and 3%. Why? Because my premise is that 2 and 3% is the consumer price index and the quote unquote target of inflation that the feds have. So why are you trying to charge me 5 if the inflation is 3.5? Let's negotiate that situation, no? Option to buy, terms and conditions. Is he, the original landlord, going to be willing to give you a contract for this? That's an interesting approach, because you are renting all the building, you are paying to him, you are good standing, but after 5 years, guess what? You only give the landlord 20%, and you have the building, you are the owner of the building, and you pay another 5 years the contract for it to the landlord, and then you have a balloon. So in actuality, you have a long, long, long period of time that obviously that was your strategy. You were saving money every month. You have no problem with the 5-year balloon. You are subject to credit and you can pay him out. No problem. That's how you can structure your purchase of big real estate, commercial real estate. And obviously the acceleration clause, run, forest run. The acceleration clause basically means that if you don't pay, the landlord can accelerate the obligation that you tenant have for him and collect it now. Example, and I have had that situation and it is devastating for the tenant. It was a contract for 5 years. They were in year number 3, 2 to go. They couldn't pay for X, Y, and Z reasons, and they wanted to terminate the lease. Well, guess what? They have an acceleration clause, and in the acceleration clause, the landlord very intelligently and tricky demanded to sign each of the tenants. It was a restaurant. They were 4 people. The 4 people have to sign personally and respond and be obliged to their own personal property. And there was a signature there. In other words, if the business is not enough to pay the 2 years that we have in the example, guess what? The landlord can go against the car, the marriage ring, the diamond, the TV, the furniture, etc. of your house. So if you see an acceleration clause, run, because the order basically delete. You are not going to go for an acceleration clause, no matter what, okay? So I think that very, very in terms of high level, we address how to approach a lease contract. Some things you knew, some things you didn't, and I'm very happy to share a little bit of knowledge in this kind of topic. As you can see here, there are lots of people, lots of paperwork involved for the deal. And with that, I really, really appreciate your presence. And I hope it was a fast 1 hour. Without further ado, Fabio, take the microphone. And if there are any questions or comments, I will be very open and happy to try to answer them. We still have like 6 minutes.
Hello, thank you, Luis, for all the information provided today. For the participants, please use the chat icon at the bottom of your screen to write down any questions so Luis can answer those for you. And Luis, one thing that somebody was asking me through email the other day, it's about when you rent or lease or even purchase real estate property, do they look at the business owner's credit score and their own information on their own, let's say, IT number or social security number? Or do they go more into the business? Do they look at the business identification number or in the business score?
It depends, Fabio. It depends upon whether you are leasing or buying and what kind of size you are buying or leasing, you know. For instance, there is the loan, let's say the purchase. If you buy a $1.25 million or more property, there is a loan that is non-recourse. Non-recourse is basically the property will respond in fully for the loan, and that's purchase price, okay? If you are going to purchase something less than 1.25, I recommend, and the banker will recommend, and they like a lot, that you go through a corporation, C corporation, S corporation, LLC, whatever your tax guy or girl advises you to form. And as long as that entity is legal and that entity is the one that asks for the loan, and there are banks that loan for with 18, and is through a corporation, meaning an LLC, etc. Then you can even get programs of financial help to purchase the property that you want. In other words, you are an 18 person, you make a LLC, you go to the bank will ask you for your income tax declaration. It's an LLC, it is approved, you can get the bank approval, and also, and we're going to see that in the next webinar, how to purchase commercial real estate, you can get also financial help. Now, for leasing, again, because it's commercial, you can do the same approach, except that you are not going to go to the bank for a loan because you're renting. But it is the LLC that will respond for your lease contract. And yes, they want to get to know you. And yes, they are going to ask you for income tax declaration. In the event, as I commented, remember that it's a new business, then they are going to ask you, most likely, for a business plan, 5 years projections, etc. But everything is possible if you know how to structure it, and you can negotiate terms and conditions and price.
Yeah, thank you, Luis. And the idea here, Luis, as I get all this information, is about businesses being prepared, being able to go out and do their research and their due diligence once they're considering a purchase or a leasing option for their business. So I really, as the Latino Chamber of Commerce, we're offering all this information. We will place the recording of this video in our website on the chat. I send the link for the previous sessions that we had already posted. This one will be posted within the next few days for anybody that would like to come back and review the information. Also, Luis, somebody in the participation group was asking if we can send the a copy of the slides. So I'm sure you can provide me with that so I can place it or send it out to everybody that is participating today with us.
Okay, so if there is no other comment or question, Fabio?
I don't think there is no more. They're just thanking everybody. They're thanking you, Luis, for the information. I think the time is up for now, and we make sure that you get, for the participants and anybody that, that will be watching this session, please check our calendar. Every once in a while, go there and check. There is a few other sessions. There is going to be a session in Spanish of this topic today. That will be next week. So if anybody's interested on having the information in Spanish, please check our calendar and sign up for that one. Also, in the next few months, we also have different topics. So check and register and pass the word. Send if you have a friend or a person that owns a business and is thinking about purchasing, buying, leasing commercial real estate, make sure that before they do that, they come and listen or participate on these webinars. So so you get the information you need and you're prepared. With that, Luis, anything else? I'll be glad to finish the session.
Okay, Fabio, excellent. Thank you very much for your invitation. And as always, I'm here to help the community and anybody else that is in a need for commercial real estate. Thank you very much again.
And I'll see you next time.
Next time, of course.
Okay. Have a good day.
En español. Bye-bye.
En español. Bye.